Good morning, good afternoon. Innovations and new technologies. To patent or to hide? That is the question. This will be the topic of our today discussion. Increasingly, the value of a business is based on IP rights and technologies of a given enterprise. We can notice that in our projects, in the projects in which we are involved, including in particular different kinds of transactions where innovative business is being sold or acquired. And while we notice that the spend and expenditures on research and development, on intellectual property rights is increasingly growing year by year, we still notice some insufficient awareness within the businesses as to the value and method of protection of their innovations and new technologies. In particular, we would like to focus on protection of new technologies by patents and confidential information, trade secrets, in more practical way, know-how. First, the business should be aware of the different purpose and the different means of protection of relevant parts of their technology by patents or by trade secrets. In more detail, patent can be granted by a given patent office for a given technical solution which is new, which involves inventive step, and which is susceptible of industrial application. But yet here we receive some exclusiveness, some monopoly on a given territory against disclosure of our solution to the public. In turn, however, when we decide to protect our information of technological nature, for example, as a trade secret, we do not disclose this to the public, we do not register it anywhere, but we observe sufficient legal and technological measures and means to keep this information secret. The protection in this case would last as long as it is secret, meaning as long as we keep sufficient measures to keep the information secret and not acceptable and not open for the public or for the relevant circles of experts acting in a given market. So what should be taken into account when we decide if and how to protect our innovations and new technologies? So there are at least a couple of factors which we should take into account. First, we should have a close look on the type of solution which we aim to protect. What kind of technology it is, what kind of technical information it is, whether it can form an invention which can be subject to patent application. Then you should take a closer look on the markets where we would like to exploit our innovations and new technologies and of course receive some kind of exclusiveness and monopoly. So in this context, we should have a close look on the legal systems in the relevant markets to check if and how a given piece of information or a solution can be protected. Then we should take into account financial aspect of our protection, meaning we need to take a close look on the scope of expenditures needed to invest to protect our invention as a patent, for example, in 10, 15 or 20 countries. And finally, we should have a look on our own readiness if and to what extent a business is ready to enforce its rights in case there is an infringement in a given territory on a given market. Because exclusive rights or trade secrets rights, they are effective and they increase competitiveness of our business as long as we are indeed ready to enforce our rights in case it is infringed. So what to do? In each case, such a decision should be based after consultations with the management board, with research and development team, with business development team, and of course with lawyers and patent attorneys to take the best possible option to protect our innovations and new technologies. What is also important here is that in many cases, technologies, innovations, for example, technological process of manufacturing a given product can be subject and can be open for protection both by one patent or a couple of patents and simultaneously also to some extent by confidential information which is not disclosed to the public. So as you may see, the decision here is crucial. It is important but in case the decision goes into the right direction, then the competitiveness of our business may increase substantially. Finally, are there any common areas which we should take into account when we decide what means and what types of rights we should apply for our new technologies or innovations? Yes, there are. For example, each business should take a close look on the relationship, the legal relationship with its creative personnel. We mean here whether the relevant intellectual property rights are in full and sufficiently assigned to the business. Then we should have a look on the freedom to operate aspect of our business. Meaning, in case we develop an innovative technology or new technologies which may be subject to our protection, but also potentially it may fall within the scope of third parties' business, it is good to have a so-called freedom to operate analysis performed in order to check whether we are indeed the first to use and to invent a given technology, but on the other hand, whether we would not interfere with any third parties who already operate on a given market and in a given sector. Then we should properly and sufficiently document protection of our intellectual property rights within the company, because this has impact not only on showing that we, for example, took sufficient measures to protect confidential information, like the trade secret, which is one of the prerequisites of effective protection, but also it is critical to show to potential investors that indeed we took sufficient approach and sufficient focus on protection of our intellectual property rights in order to show our company as indeed IP focused and competitive on the market, which will in turn increase the value of a given business. Thank you very much.